Good afternoon, and welcome to the April 10th version of the Question and Answer Virtual Lunch Hour with Jason Killeen. I'm your host, Jason Killeen, Assistant Executive Director over the Department of Cannabis Regulations Licensing Functions. As part of this week's opening remarks, I just want to remind folks that Dr. Brown and the Social Equity team are doing their Equity Week Training Summit, which is tomorrow from 10 a.m. to 3 p.m. There's information on the screen for how to RSVP for the event. The event is going to be held at the Amundsen Senior Center at Exposition Park. There's free parking for the first 50 vehicles that attend, and they are providing lunch. The purpose of the Equity Week Training Summit is to get attention for the social equity community, to provide investor-friendly business structure and improving marketing strategies, to link folks up with various subject matter experts that can help prospective social equity applicants as they move forward with either pursuing a commercial cannabis license or for existing licensees, what resources could be available to you. So it's definitely something to consider attending. It is a free event, free parking for the first 50 vehicles, and they will be providing lunch. So this is one chance to take advantage of some of that business licensing and compliance assistance training that the department provides. And with that, we can go ahead and get started with questions.
Good afternoon, Jason. Our first question comes from Yvonne D. When is the PCN process opening up again?
We don't have a tentative date for when that process will reopen. It could be later this year or sometime in 2025.
Ivan also asked, can I apply with multiple applicants on a PCN application?
The PCN process is an extension of the pre-application review process. So when you submit your pre-application, you have to identify the legal business entity that is pursuing the opportunity. So to the extent that there's multiple owners, primary personnel, or indirect owners on that legal business entity, you can go ahead and include them on your pre-application request. If you're looking to try to tie multiple legal business entities, you can only have one legal entity tied to each PCN application request.
Our next question from Robin W. If a present retail operator leaves a community plan area that is at its capacity for retailers, can an SEIA with retail license opportunity move into that location, thus keeping the same number of allowed retail operations per area?
If a community plan area has reached undue concentration, which means that DCR has issued the limited number of licenses we can issue in the community plan before a PCN finding is required, the only way you'd be able to submit an application or relocate into that community plan would be if it was no longer unduly concentrated. So for instance, Central City, which covers the downtown area, is unduly concentrated, and there's more than 3 licenses issued above and beyond what DCR has the non-council approval to issue. So even if one of those licensees relocated out, it would still be considered unduly concentrated, and we wouldn't be able to accept an application or a relocation to backfill that one. In order for it not to be considered unduly concentrated, 4 businesses would have to move out to create the opportunity for one business to move in.
Thank you. So Robin W. asks, what's the process for an SEIA to get a nursery license?
You would have to submit a pre-application for the nursery activity through the DCR licensing portal.
Next question from Lee L. How can we get in line on Zoom to speak during a retail community meeting?
If you've joined the meeting via Zoom, on the bottom or wherever you have the Zoom icons, there is an option to raise your hand within the meeting. So you would just go ahead and raise your hand um, next to your name, and then it would indicate to staff that you wanted to provide public comment.
And then our next question from Deirdre H. If I'm already considered a social equity applicant with an ADA number, would I have to go through SEIA eligibility verification process this month of May?
So for any of the activities that are currently available to social equity applicants through the portal, you would not have to get re-verified to apply for what's available to all verified SEIAs currently. As part of future lottery processes, you may have to get verified to meet whatever criteria council and the mayor adopt in order to participate in that process. But currently, we're not accepting new eligibility verification requests, and it's probably not going to open up for several months until we've gotten a number of our retail applications through the public hearing process in the commission.
A follow-up question from Deirdre H. If I miss the window to apply as an SE applicant, may I still apply for a manufacturing and delivery license as a non-SE applicant?
At this time, non-social equity applicants can apply for the Type 6 non-volatile manufacturing, commercial cannabis activity, and other non-volatile manufacturing activities. However, the delivery license type is limited to social equity applicants for the remainder of calendar year 2024.
Richard C. asks, can you have more than one DBA or doing business as for a delivery license?
Yeah, as long as the fictitious business name, also known as a DBA or doing business as, is properly registered with the LA County clerk, and you've submitted the information to show that that fictitious business name has been registered to the entity.
Our next question comes from three individuals, Richard C., Narbe A., and Nakia G. When will phase 3, round 3, take place for social equity?
There's not currently a timetable for phase 3 retail round 3. We anticipate transmitting some recommendations to the city council this year. And once the city council has had an opportunity to consider those modifications, we may have the authorization to conduct another lottery.
From Miyoko T, where can the community access education and resources?
It really depends on what type of education and resources you're looking for. I would definitely recommend starting with the department's website. The banner at the top of the webpage breaks it down by different functional areas, whether you're looking for information about the commission, licensing programs, compliance, how to identify licensed retailers, etc. And then for verified social equity individual applicants, folks also have access to the department's learning management system or LMS system, where all kinds of different supplemental information and training courses are available.
Our next question comes from two individuals, Ali R. and Hopanis B. When will retail storefront businesses that are not in operation receive their annual CEQA notice of complete operation?
So currently we're prioritizing processing folks who have provisional licenses that expire in July, August, and September. Starting with batch 4, we're going to begin to fold in new retail storefront businesses that don't currently have a state provisional license. And ultimately, the drafting of your environmental document is part of getting to a notice of complete application. And then that environmental document, assuming it's for retail storefront, um, that application will go through a community meeting process, a public hearing process. And once a decision has been made to issue an annual license, then and only then can the department actually file the environmental document, so that you would be eligible to get your local annual license and then ultimately complete the process to get your state annual license. So it's going to be sometime in the next 3 months that we'll begin to process records that are not currently in operation, as we get capacity with additional environmental consultants coming on board to process those 4013 forms.
Thank you. Moving on, Jasmine Z asks, I'm a tier 2 qualified. Can I do delivery instead of retail?
Verified social equity individual applicants can submit for a legal business entity record where you register the legal entity that wants to pursue the commercial cannabis activity. And as long as the entity meets the equity share requirements to apply for the delivery, you'd be able to apply for delivery as a social equity business.
Question from Anthony T. Can you explain the aggregate social equity interest? For example, does one social equity applicant with 33.3% and another with 17.7% ownership in a parent entity qualify as aggregate 51%?
Based on the simple math, yeah. The aggregation just means adding up each verified social equity individual applicant's ownership percentage within the applicant. So in this scenario, one verified SEIA with 33 and a third, and another verified SEIA with a total of 17.7, even if that ownership is held through an intermediary entity, would get you to an aggregate of 51%, which would, on the face of it, meet the requirements of 10420.
David W. asks, can I pursue 3 locations at the same time once new licenses start being accepted again?
It depends on what activity you're applying for. For things like delivery, non-volatile manufacturing, distribution, those are not subject to findings of undue concentration, and there's no cap on the number of licenses an individual can be an owner on. Things like retail storefront and cultivation are subject to findings of undue concentration, and there are limits on how many applications a person can be listed as an owner of. So if you were selected through a lottery to apply for, let's say, retail storefront, that lottery would only allow for you to submit one pre-application record at a time. And if the record is eligible for processing, you'd have to make a business decision about whether or not you wanted to move forward with the location or surrender it and try to pursue a different location. But you can't try to plant 3 different flags to move forward with one licensing opportunity.
JB has this question. How can future dispensary owners find a good payment processing company?
So DCR doesn't provide business advice, but for verified SEIAs and other folks, you have access to the learning management system. You may have access to the pro bono, low bono legal services, and then you can always attend any of our training events like the one tomorrow, where there'll be subject matter experts in the commercial cannabis fields that will be providing information and resources, and that may be helpful to you.
A question from Alex B. Will phase 3, round 1 social equity applicants be allowed to sell or transfer 50% dispensary ownership stake after January 1st, 2025? And if not, when?
At the moment, they would not be able to sell the ownership stake after January 1st, 2025. That's still an outstanding policy question about whether or not the mayor and council will support allowing social equity licenses to transition to general licenses, or the code as written requires a social equity license to continue to be a social equity license and meet the requirements even upon renewal with the equity share requirements in 10420.
Nita M asks, when do you foresee City Council agreeing to PCN applications?
When when the PCN records get transmitted for council consideration, council has 90 days to make a PCN finding. If they don't make a PCN finding within that 90-day period, the PCN request is denied by operation of law. For the 9 PCN records that were timely submitted, the last day for council to act is next Wednesday. And if council hasn't made the necessary findings by April 17th, then those files will be denied by operation of law.
Thank you, Jason. Brittany B asks, what would you say is the hardest part of opening and establishing a business in cannabis?
Again, DCR can't provide business advice, but feedback we've gotten from industry insiders is access to capital is one of the most difficult things, because you need capital in order to meet the regulatory requirements to operate a business and stay in compliance with all of the various laws and regulations that different agencies have. If you, again, I would recommend folks, look at the website, look at the learning management system, and then attend the different events that our social equity team is putting on, because we do have subject matter experts that are in the industry and work with owners of businesses in the industry that can really speak to the challenges that they've faced and how they've, had to overcome different challenges and what resources are there to help you overcome those challenges.
A question from Brittany B. What are the statistics for African American women owning dispensaries in the state of California?
I know for the city of LA, we do have African American women who own dispensaries in the city of Los Angeles, but that's not one. DCR doesn't compile demographic information as it relates to owners of businesses. The state may have that information, but that's not data that the city collects, and nor are any of our licensing decisions made on any demographic factors.
Jorge T asks, if a daycare is located within a fenced private property with a single address, for example, a university or movie studio, is the 700-foot buffer zone from the wall of the building occupied by the daycare, or is it the parcel boundary?
Based on the example provided, it would be from the exterior wall of the building where the daycare is occupied. In this example, I'm getting to the private property is not solely a daycare. It has some other use, whether it's a university or a movie studio. In the event where there's more than one type of activity occurring on the parcel, it's the closest exterior wall of the building.
Thank you. A follow-up question from Jorge. If a site was the location of a padlocking or other type of enforcement action, is the entire building or the parcel disqualified, or just the address or specific unit with the violation?
I'd have to see what the enforcement action stated. If the enforcement action was tied to like a specific building on the property or a specific address on the property, and there's multiple addresses on the parcel, then generally the enforcement action would just be limited to that. But if you have one legal address tied to a property, even if there's multiple buildings or units on the property, and the whole thing was enforced against, the entire building or parcel would be disqualified. It really depends on how the enforcement action was written up and what the enforcement action was targeting.
Thank you, Jason. Mikia G asks, if I was awarded a PCN license, but I am having problems with the landlord, at what point in the process am I allowed to move to a different location in the same CPA?
I mean, the key was in the question. It's a license. So if you were granted a public convenience or necessity finding by the city council, that gives DCR the authority to process your application. Once that application results in licensure, whether it's temporary approval or an annual license, you would be able to request a relocation pursuant to the relocation requirements in our code. Pending applications are not eligible for relocation. And if a PCN application is deemed abandoned, it can only be refiled at the original location because that's where the PCN finding was granted. So in order to relocate a PCN record, it had to have resulted in a license, and it's the same rule for any other application is only when the license has been issued can the license be relocated, subject to whatever the relocation rules are.
A follow-up from Makia. When will DCR allow social equity applicants to apply for cultivation licenses?
We'll see. The part of some of the amendments we're going to be pursuing with the city council this year is looking to expand the lottery process to also include cultivation. I think the last time I checked, there were fewer than 100 cultivation licenses that the department could issue prior to having the entire city be subject to a finding of undue concentration. And the current PCN resolution adopted by council doesn't contemplate, reasons why a cultivator may be eligible for a public convenience or necessity finding. It's really the PCN process now is kind of targeted for retail storefront businesses. So one, it's how do we equitably give out the ability to applicants to apply for cultivation? And then two, once we've reached undue concentration in the various community plan areas, is there a mechanism for folks to pursue a PCN request with the city council? So those are two things that will need to be resolved before DCR begins accepting cultivation applications again.
The next question comes from Raymond R. Are the operations of illegal dispensaries being enforced by the city of LA?
Yeah. The police department, the Department of Building and Safety, the Department of Water and Power, the fire department, they all have different enforcement tools that they can use to address unlicensed commercial cannabis activity. But each of those agencies are also charged with enforcing a number of other laws and regulations and codes within the city. So it's just a small subset of what they have to do. So, each of them have to prioritize kind of the public safety and health and welfare benefits of taking an enforcement action against an unlicensed business against, all of the other priorities and things before them. But the city is enforcing against unlicensed dispensaries.
Omar R. asks, I'm a phase 3 retail round 2 retail license selectee. We are told we are in the third group and the processing time for a completed annual license application is 90 to 100 days. We took over a retail vitamin shop and do not have any construction. Are we able to get a provisional license while we wait for our hearing?
You'll have to, if you have not already done so, you would have to apply for a provisional license with the Department of Cannabis Control. With the adoption of Senate Bill 51, which went into effect in January, the Department of Cannabis Control has authorization to process additional provisional license applications for social equity applicants pursuing a retail license. So you could, at this point, apply for a provisional license with DCC. And if they grant the provisional license and you get temporary approval from the city of LA, you would be able to lawfully operate while you wait to go through the community meeting and public hearing process. But you do have to possess a local license and a state license in order to operate.
Thank you, Jason. Ron S. asks, when will non-equity applicants be able to apply for a retail license? What is the time frame?
Currently, the municipal code limits retail storefront and non-storefront delivery applications to social equity applicants through January 1st, 2025.
Jamie B. asks, can a social equity applicant put a license on hold?
I don't understand the question. Like, it's a little bit more nuanced. If an applicant does not have site control, we have to be notified, and because licenses are location specific, it would result in the abandonment of the record or the cancellation of the license. We did amend the code last year or the year before to create a pathway for folks that have an expired license to reapply for that license within 3 years. If you are hypothetically licensed in calendar year 2024 and you're going through a tenant improvement and it's going to take 3 months to complete the build out before you can operate again, you can notify DCR that from April 1st, 2024 through July 1st, 2024, the business is going to be closed while you do tenant improvements at the location. And then we'll make sure that we do updates on our website so that members of the public know that there's a license there, but the business is not currently active. But if we license you at location A and you no longer have site control of location A, you can't like hold your license at location A. Like it's no longer valid.
Moving on, L'Oreal A asks, is there any sponsorship for licensing fees for prospective applicants?
For prospective applicants, for most prospective applicants, the answer is going to be no. DCR does not have funding for waivers, and the waiver monies we have through grant programs are generally targeted for either social equity applicants, like our cannabis equity grant monies, or specifically for folks who meet the requirements of the local social equity program, and there's limited uses there. And then our local jurisdiction assistance grant monies can only be used for businesses that have existing provisional state licenses that need to complete the environmental review to transition over to annual licenses. And the state has been clear that in order for a business to be eligible for that, one, they have to have a state provisional license, and two, those monies are limited to the environmental review to transition them from provisional to annual. So unless you fall into one of those two buckets, there are no other sponsorship to cover licensing fees provided to prospective applicants.
A follow-up question from L'Oreal A. Is there literature available that details all types of licenses and possible fees associated with each license?
Um, both sets of information can be found on the DCR website, and like a full list of the fee table is available through the municipal code.
Thank you, Jason. Next question from Rick T. What is the process after communities reach undue concentration of dispensaries? What are the steps an applicant must take, and who makes the final decision for an applicant after undue concentration is met?
Well, when undue concentration is met in a community plan area, DCR no longer has authority to process additional applications without a public convenience or necessity finding. Only the city council can make a public convenience or necessity finding. So any prospective pre-application record or application that needs one of those findings would be transmitted to the city council for their consideration after applicable documents and fees are paid. And then the city council has 90 days from the date of transmission to make a public convenience or necessity finding. And if a finding is not made, the request is denied by operation of law, which effectively closes out either the pre-application record or the application record.
Our next question from Rita Y. Do you still require a temporary application or just an annual application starting from 2024?
DCR phased out the standalone temporary approval application process in summer of 2023. So for the entire calendar year of 2024, we've only accepted annual license applications. There is a pathway within the annual license application process for folks that have a state license for the activity to pursue temporary approval while they work towards getting their annual license. And there's language in the municipal code about how somebody could, request temporary approval once they've received their corresponding state license.
Question from Hofanis V. What is the timeline in which all documents should be completed by DCR? I have been waiting for years. What is the max amount of time an applicant has to wait?
Like I don't quite understand the question. Um, if it's truly been 4 years, the application would have been submitted when DCR was only accepting temporary approval applications. And to the extent that you met the filing requirements and the inspection requirements to receive temporary approval, you would have. So I'm not 100% sure what they're asking. And if you failed to meet the requirements to get temporary approval, the record should be deemed abandoned. And then you could reapply at the time that you're able to meet those requirements.
Our next question comes from Narbe A. When is the cultivation license application opening again?
We don't have plans to open the cultivation application process. We are going to be requesting for the city council to allow for us to include that as part of the next lottery, given how few application opportunities are left citywide.
Our next question from Brenda L. How many dispensaries are allowed within close proximity of each other?
The code requires for retail storefront businesses to be 700 feet apart from one another, closest exterior wall to the retail activity between the two businesses. Some community plan areas allow for 20 or more retail storefront licenses, and provided each of the businesses were able to locate outside of 700 feet of one another, they could all be concentrated in one geographic area within that community plan area. Um, the proximity selected for our code is 700 feet between businesses, and that's what we work off of.
Thank you, Jason. Let me know if you need me to repeat any part of this next question from Samuel M. When the city is doing background for a social equity license, if it goes to the third phase, does it mean that your background has been checked and everything is passed?
I don't know what third phase means.
Okay, moving
Like
on. Go ahead.
the as part of the licensure process, staff conduct an equity share review to review the operating agreement and the business formation documents to determine whether or not verified SEIAs have the required equity share on paper in the business entity. And, we look for the voting rights and some of the other things within the code. But DCR doesn't actually do background checks of individuals, whether they're a social equity individual applicant or they're a general applicant. That background checks, live scans, those are all things that are done at the state level, not the local level. We do one check to see whether or not an individual meets 2 out of the 3 criteria to be considered a social equity individual applicant. That's low income, prior cannabis related arrest or conviction, and residency in a disproportionately impacted area for the number of years required by the code. And then the entity itself has to be made up of social equity individual applicants that have an aggregate equity interest that meets Municipal Code Section 10420. So there's not like, I don't know what they're referring to by third phase, um, or what they mean by like background check. So hopefully the information I provided helps.
Thanks, Jason. From Jesse R., the question is, are first-time applications being accepted? If so, can I request personalized assistance?
I mean, there's application types that are limited to social equity applicants and application types that anybody can apply for. As long as you have registered the legal business entity that's going to be pursuing the commercial cannabis opportunity, we accept first-time applications. In terms of personalized assistance, depending on where you are in the process, there's an assigned analyst who can answer general questions related to your particular application. But there's not somebody who's going to sit down with you and help you fill out paperwork or do anything else. Those types of one-on-one services are only provided to social equity applicants through one of the programs administered by the Dr. Brown Social Equity team. And those are contractors who are hired specifically through either business license and compliance assistance funding or state grant funding to provide social equity applicants with assistance in completing the application process. So if you're a verified social equity individual applicant and this is your first time applying, you can reach out to the DCR SEP team to see if you would qualify for some type of one-on-one coaching or other assistance through one of their programs.
Jesse has a follow-up question. What's the total cost to get licensed and keep the license, and what requirements do I have to meet?
If if you were to hypothetically think about securing a location, paying local regulatory fees, state regulatory fees, and going through the permitting process to get licensed for both, it's going to be over $100,000. And you're going to have, local requirements based on the municipal code, the rules and regulations. You have to comply with building code, fire code, public health code, and then all of the state law and regulations that the Department of Cannabis Control have. And then, of course, maintaining the license, you're going to have to renew the license and continue to pass compliance inspections. And there's a continuing obligation to stay in compliance with local law, state law, and all codes and regulations.
This question comes from two individuals, Yuvia A and Brenda L. I'm wondering what the vetting process is for opening a dispensary. Are there regulations about having too many dispensaries within a city? And some of the dispensaries where I live are not too far from schools.
The applicant submits an application to the Department of Cannabis Regulation and the State Department of Cannabis Control. They navigate through that application process. The city has a soft cap on the number of retail storefront businesses that can operate within the city. The caps are set by community plan area. At the current time, only 5 community plans have reached undue concentration where additional applications have to get that PCN finding. But in the other 30 plus community plan areas, DCR is still able to process applications and issue licenses. Retail storefront businesses just have to be outside of a 700-foot radius of a school. And we go based on publicly available information posted on the State of California Department of Education website for the legal address registered to the school, and then what address that, what parcel that address is assigned to. And that's how we do our measurements.
Let's see, our next question comes from MS. Generally speaking, is it a problem if an applicant and their representatives are not available to present in person during the Cannabis Regulation Committee meeting? Would they be able to present and address questions from the commission through Zoom?
For the first part, it could be a problem if the applicant or their representative is not available to respond to commission questions during their public hearing. Depending on what line of questions the commissioners may have, it could result in the continuance of the item or the denial of the application. So having somebody available is generally in the best interest of the applicant entity. We did have representatives of the applicant present via Zoom during our first public hearing last week. So I know that is an option. Our licensing analysts have been reaching out to folks who have public hearings coming up next week on the 18th to identify, who would be representing, the business during the meeting, so we know beforehand who should be called upon to speak on behalf of the applicant entity. Because we do have the Zoom link and we do have the ability to unmute folks to provide comment, it can be done through the Zoom link, but I would recommend making sure the assigned analyst knows so they know who's going to be presenting and whether it's going to be in person or you're requesting to do it through Zoom.
Thank you, Jason. This is a follow-up from MS. How long does it take to finalize an ESR? I'm assuming that's equity share review after the equity share review fee has been posted and verified by DCR.
I want to say it's done within 30 to 90 days, um, assuming the analyst has everything they need to review the documents. A lot of the delays I've, come across with the equity share review are back and forth between the department, the applicant, and or the applicant's representatives about interpretations associated with how the business entity was formed or the operating agreements for the business entity. Questions like voting rights, questions about, who's making material, decisions about business matters and, the right of first refusal and some of the other things that go in there. Sometimes there's there's questions that DCR personnel, including myself, can't address on the face of it. And we do have to seek guidance from the office of the city attorney. And, sometimes it takes them a little bit of time to research issues and provide us their legal advice on that matter. So generally, I would say 30 to 90 days. If it's been outside of that, there's probably a reason for it. And if you talk to our analyst or you give us a call, we could probably tell you what we're trying to resolve.
Our next question comes from Leo. When will the pending applications map be updated?
I'm hoping this week. So I'm trying to have it updated by the 15th. So the raw data for records through the beginning of April has been downloaded. We're in the process of rendering the data for the mapping layers, and it'll either go up Friday or by Monday at the latest.
Our next question from Palia B. If we are an existing operating licensee and submitted our 4013 forms as part of our 2024 renewal applications, is there anything else we need to do at this juncture to work towards annual licensure, or are we simply waiting on the city to issue environmental documents, CEQA NOEs?
I would specifically reach out to your analyst to see if everything has been submitted. The 4013 forms are getting routed to environmental consultants who are assisting based on kind of our aging report in completing the necessary environmental document that we need to get to a complete application. And then once we get to the notice of complete application, we can prepare the staff report either for the department to review and approve and or to, start going through the community meeting and public hearing process for the commission to consider it. But the environmental documents have to be completed and drafted to get to a notice of complete application. And then, of course, the department or the commission have to approve the issuance of an annual license plus adopt that environmental report before we would be able to file a notice of exemption, if applicable, with the county clerk and the state of California.
Our next question, again from MS. If a retailer has received a notice of complete application, but has opposition from its local neighborhood council for reasons that are not listed in LAMC 104.04, does the applicant have any reason to worry?
I don't know. There's not enough information there. The the reasons to deny listed in LAMC 10404 are the same for the department and for the commission. So if it's not one of the reasons to deny under 10404, the department is going to recommend approval of the annual license. Depending on what the concern is, to the extent that it's like public safety related, the commission does have the authority to impose conditions to address public safety related issues. But again, the reasons to deny are listed in 10404, and we don't have the discretion to go beyond those reasons. But you don't need support from the neighborhood council to be issued an annual license, but it's always good for the applicant to understand why there's opposition to from the neighborhood council, because the commission may ask, what the concerns are and how you've, handle those concerns, or whether or not there's anything you can do to address those concerns. Um, and for folks out there that are going to be going through their public hearings, we did complete the first set of public hearings on April 4th. The commission recording is available on the department's website. And it may be beneficial to you to just listen through the meeting to kind of see or to listen and hear the types of questions the commissioners asked as it related to the processing of the application and some of the information that was contained in the application. Off the top of my head, I don't remember any neighborhood councils actually directly addressing the commission. I know some of them had submitted like comments and feedback form, but I haven't seen a community impact statement from one of them yet. So hopefully that helps.
Thank you, Jason. Question from MS. Is my understanding correct that phase 1 and phase 2 cultivation licenses do not count against undue concentration limits? If so, wouldn't the city have full capacity?
They count the issuance of a license counts towards the undue concentration limit. Phase 1 and phase 2 applicants were not subject to a finding of undue concentration. So for phase 1, that's what allowed for community plan areas like Central City North, Venice, Harbor Gateway, I think Sherman Oaks, to become unduly concentrated, is because the business wasn't subject to the finding. They didn't have to get a PCN finding from the city council. But the issuance of the license counts towards triggering undue concentration. And it's the same for retail, storefront, and cultivation. On the DCR website, under the licensing category, if you go to the licensing map, when you scroll down, you'll see the community plan areas, and it's got a tab for retail storefront. And then also you'll see on that same embedded table, there's a tab for cultivation. If you click on the tab for cultivation, you can see how many community plan areas have actually reached undue concentration. And you can see kind of how much capacity DCR has to process applications and issue licenses, and the CPAs that have not reached undue concentration.
Our next question comes from Rafi S. If we have a cultivation license and we lost our site control, is there a specific timeline to transfer the license to a different location? What is the process?
For the code was amended to allow for businesses with an expired license to refile within 3 years of the expiration date of the license. So if you've lost site control and you have a license, you could submit the 4015 form to cancel the license. And then on the date that that form gets processed, the license would be considered expired, and you would have 3 years from that date to initiate the pre-application review process for a different location. You should, make sure that you're not waiting until the last day to try to submit that, because in case the pre-application is, ineligible, or you're not able to move forward at the location, once that 3 years has expired, we don't have the authority to allow you to continue to refile or consider additional refilings. So in general, 3 years from the date of the expiration of the license.
Jason, I just wanted to check on time. We have about 4 minutes left and about a half dozen questions, more or less.
Let's get started on the next set, and in between questions, I'll let you know if I think I can go maybe 5 minutes late before I have to start getting ready for the next meeting.
Okay, thanks. Our next question from MS. How far after the DCR compliance inspection should a licensee expect an official correction sheet?
I would say generally within 30 days of the compliance inspection being completed. To my knowledge, the inspector generally does an overview of some of the actions that may require correction while they're on site so that the licensee has the opportunity to get a jump start on addressing those deficiencies while they wait for the official correction sheet.
A question from Ariella J. Is DCR currently accepting nursery applications for SEIA applicants?
Yes, we are.
And then Ariella J. also asks, will DCR continue processing an ownership modification request to an LBER after the licensee files a business premises surrender form?
Can you repeat that one more time?
Sure. Will DCR continue processing an ownership modification request to an LBER after the licensee files a business premises surrender form?
Generally, the answer should be yes. Based on the way the question was asked, the ownership of the legal business entity that was registered is, being changed. It's not an entity substitution or anything else. So the filing of a business premises surrender form should have no impact on it. The only thing I can think of is if the business premises was being surrendered to trigger like the abandonment, and possibly they were trying to do an entity substitution, and that's all discussed in the refiling process. But if it's strictly the LBER and the owners of the registered LBER that are changing, nothing to do with that legal entity, it's fine.
Another question from MS. Would DCR or the commission care if a retail licensee chooses not to go through the local neighborhood council's plum committee if the neighborhood council is insisting to do so?
The code only requires the applicant to notify the neighborhood council and offer to meet and address questions. So that's what DCR is looking out for is, did you make that offer within 10 days of receiving your notice of complete application? Whether or not the neighborhood council takes you up on the offer, or they try to schedule, or they're not able to schedule, or they want you to go through something, we're just looking to see if you met the obligation to offer to meet. The commission, they could ask you questions about why you did or didn't meet with the neighborhood council or follow it, but that's really outside of DCR's purview. And if you were unable to attend their plum committee, or you didn't follow what the neighborhood council was insisting the applicant do, that itself is not grounds to deny the issuance of an annual license.
Anahi asks, do you need to have all permits and operating permits before the annual license and CEQA notice of exemption is issued?
Not under the current law. DCR worked closely with the mayor and city council last year to shift the burden of the final inspection until after the annual licensing decision is made. Once you've received your annual license and you've gotten all of your necessary permits, certificate of occupancy, health permit, your state annual licenses, you're eligible to request a final inspection. And as part of that final inspection, the inspector will be checking to make sure that you have all of your licenses and permits and stuff in order to get your operating permit for the location. But the issuance of an annual license, the filing of a notice of exemption, if applicable, is not tied to permits and things outside of DCR's purview.
And I believe we have our last question from Anahi. After getting an annual license issued, how will entity substitutions be processed? And then the secondary part, will it be easier or more difficult to change an entity name and relocate?
I don't know. You know, entity substitutions themselves are new applications. So the license doesn't just transfer from business A to business B. Business A indicates that it wants to move that opportunity to business B. Business B submits a completely new application and goes through the entire application process. And if and only if business B meets the licensing requirements, does business B get a license and business A cancels their license. The state has always required provisional licensees to submit new applications. They haven't allowed for folks to do like entity substitutions and relocations as part of the same application record at the state level. And it's unclear right now whether we'll be able to make it a more seamless process, or it'll be the same, file a new application and go through the application process to facilitate the transfer of a license or an entity substitution.
Thank you, Jason. Congratulations, you finished all the questions.
Wonderful. I want to thank everybody for coming today. I do want to remind folks that Dr. Brown and the social equity team will be doing their social equity event tomorrow, which is part of the training summit. It's from 10 a.m. to 3 p.m. It's at the Amundsen Senior Center. There's a link that I know folks dropped into the chat. We have it up on the screen right now so folks can get more information and they can RSVP. Amundsen Senior Center is at Exposition Center. It's located at 3990 Bill Robertson Lane, Los Angeles, California, 90037. It's a free event. The first 50 cars to attend get free parking, and they are providing lunch. This is an opportunity for folks to meet with various subject matter experts in the industry. And then if you're wondering when we're going to do the next virtual Q&A lunch, it's going to be on May 25th at noon. So look forward to talking to folks then. Thank you and have a great day.